Chris, you ready?
I don't want people to judge me.
Whenever you're ready.
Just let me know. You ready to go?
We're ready. We're all good.
Okay. Yesterday, the Supreme Court has confirmed that police officers can no longer use the hyperbole and the dehumanizing evidence of victims of police misconduct. It's a very important decision for all victims of police misconduct in the state of California. And we're very happy and ecstatic that the U.S. Supreme Court has denied the application for the written certiorari. My clients are here, Genevieve Huizar, and she wants to say how she feels about this decision.
Thank you all for being here. I just feel very blessed. You know, right from the beginning, I've given this to God. It's, you know, God that's made it this far, and I am just extremely happy about it because we have been fighting this far, and, you know, I'll never forget my son. Never.
Again, across the state of California, when victims of police misconduct are shot by police officers, the police officer defense attorneys often engage in a course of conduct of using the factors of the person's life that the officer did not know about. The decision in the Manuel Diaz case, Ms. Huizar's son, says that cannot be done. Those shenanigans cannot happen. And those defense attorneys are handcuffed from being able to do that in the future on future cases. That's what's so important about this case. So that now people have a better chance at justice, because now the decision of whether or not that officer used proper force will be solely on the facts and not on some baloney that the officers find about after the shooting.
Ms. Huizar, can you talk about this process and talking about the appeals court, the decisions that were made along the way, and kind of the roller coaster of emotions for you?
Yes. You know, initially,
Can you come a little closer to the mic?
Initially, the shock of my son being killed, the shooting of him being shot in the back of the head, and going through all the emotional grief, and just having to live without him. He was my only son, and he had just had his 25th birthday, and he doesn't have children, and he was denied being a husband, a father, you know, just all of that. And then we go to federal court, and the jury finds Officer Bennalack not guilty, and so then my team of attorneys, Dale Humberto Huizar and Angel Carrasco, have then filed the appeal. So we go to the 9th District, and we won, and it was just like, thank you God again. And yesterday finding out about the Supreme Court decision was just an amazing part of this fight, but we're gonna fight to the end. You know, we have to keep going. This has to stop police brutality, police murders. It's going on across the country, and there's no accountability. And if my son's case can help other cases, future or past, that's what we're here for.
When I know this is a civil lawsuit, what is the end for you? I mean, what is your ideal scenario and your ideal verdict?
That the cop be arrested for murder and do time like anybody else. If you killed, you would be doing time. If I killed, I would be in prison. So why don't the cops go to prison? Why? And if they do, why don't they do the full term that they're given? You know, it's just really difficult. I would like to see him in prison.
Ms. Huizar, when they brought up some of your son's past during the actual trial, was that frustrating for you? I mean, were some of those things untrue for you, or where were you with all those?
It wasn't so much that it was untrue, but it had nothing to do with the day that he was shot in the back of the head. He had a cell phone, not a gun, a cell phone. And if he's running away from you, how is that a threat? You know, there was no threat to the officer. He came around the corner and he opened fire automatically. There was no threat to him. And that officer has killed 3 times.
Mr. Huizar, the Police Officers Association has called this decision, SCOTUS not looking at this, as a dangerous precedent. For you, this is a precedent the other way, in that it would be favorable for you, correct?
It's ridiculous to categorize it as a dangerous decision. A danger to who? I think it's a public safety issue that police officers now need to know that when they shoot somebody in the back, they can't go to someone's cell phone, get pictures, and then say, I shot him because this person was doing this a month ago or 2 months ago. We have to decide the case on the facts. It is dangerous for this reason, for the fact that we know that the people in charge of investigating these police shootings, especially here in Orange County, the Orange County District Attorney's Office has no transparency whatsoever. They go out there and they do powwows with the police officers involved in the shooting. They go through the crime scene, they immediately look for negative, dehumanizing parts of the victim instead of evaluating the forensics of the shooting accurately like they would in any other murder case. If that's dangerous, then I guess it's dangerous to be fair and to execute the law properly in California. I don't think that's the case. I think what the Supreme Court has said, keep in mind, this is a conservative court now, and all of them said that they weren't going to consider it. Why? Because that case by the Ninth Circuit is a very good case that solidifies when police officers or police defense attorneys can use evidence, negative evidence about someone's life. Prior gang background, use of a gun. If it's not known, if that information is not known to the officer at the time he fires, it cannot be brought into court during the case in chief, during the determination of liability. That's only fair. We never, as plaintiffs' lawyers, ever get the information about police officers when they kick their dogs, when they slap their wives, when they push and mistreat people. That evidence doesn't come in, but yet they get to bring in, they've been able to bring in negative evidence when they take someone's life away. They bring that evidence in, and I think it's giving us a more equal, like the scales of justice are, a more equal balance to fairness and justice in America.
Ms. Huizar, what do you say to all the folks that protested in reaction to this ruling initially, and that were upset and frustrated not only about your son's case, but about a series of officer-involved shootings and killings in the weeks that led up to yours?
Well, the mantra of no justice, no peace, it comes from Black Lives Matter all across the country. Not just Black Lives Matter, but even Blue Lives Matter. No justice, no peace. If somebody kills a police officer, you can't have justice. You can't have peace unless that person is brought to justice. Same holds true for victims of police misconduct. That mantra of no justice, no peace, it comes out when people see that someone's shot in the back of the butt, in the back of the head, and the officer walks away with not even a slap on the hand. That just cannot be allowed to happen in America. We deserve a right to have a fair trial, and that's basically what the Ninth Circuit said was that was not a fair trial. It was not fair. And now the Supreme Court has ratified that decision. It's very important to note that by saying we denied a written certiorari, it's made that case, the Manuel Diaz case, a very powerful case in California, that when people cite it, it will be looked at as authority on these type of cases. And we're very, as a plaintiff's lawyer, I'm happy because I'm able to present these cases to a jury in a more fair way. And we're not asking for handouts. We're not asking for special treatment. We're not asking for special evidence. Just fairness is what we're asking for. And the Supreme Court has recognized it by denying this written certiorari.
So where do you go from here legally?
Well, we have a trial coming up in October. We're going to get a second chance at justice. And now the jury will not be told about all this negative evidence. The jury will be asked questions about whether or not the use of force was reasonable or excessive under the circumstances. And they'll make a decision not based on hyperbole or negative, dehumanizing evidence.
Ma'am, are you prepared to walk through this all again, being back in court?
Yes, I am prepared to be going back to court. I want to go all the way back. You know, this is, like I said before, my only son. Until I take my last breath, I'll fight for him. I remember him every single day. I cry for him. I would love to see him.
Thank you very much for giving us some attention. We appreciate it. First name.